Okay, so hello and welcome everybody who joined to another SEBAversity Sunset Event. My name is Marcel Harman. I'm the head of SEBAversity, the non-profit and educational arm of the bank. At SEBAversity, we offer a wide range of educational activities, and I just suggest that you check out the website sebaversity.swiss. I'm sure it's worthwhile. We have different material on the of DLT technology, law and regulation, business at different levels for the curious, the explorer, and the natives. That's how we call them. So I'm sure you find interesting articles, videos, or recorded events of the past, depending on your customized level. But today's session is really about digital estate and how to not lose your crypto assets. So thank you very much, Alexandra Geiger, for joining today and giving us this interesting lecture. Alexandra is a partner at MME Legal and a certified specialist SPA inheritance law. She advises and represents domestic and foreign clients in the areas of property and inheritance law, estate planning and administration, company succession, as well as foundation and trusts. And thank you so much for being here, and I'll hand over to you.
Okay, thank you very much for the kind introduction. I would like to welcome everybody as well. Good evening, and I'm very pleased to talk about crypto assets in your estate tonight, and also how not to lose them. If you have any questions, I propose that you give me to or ask them at the end of my speech. I am very happy to answer them. So let's start. How that works. So, yeah. I'm sure you're familiar with headlines like Bitcoin's death problem, how billions of pounds worth of crypto assets are being lost when people die. Or you heard about a crypto exchange may have lost 145 million because the CEO suddenly died. So that is why you are here, and that's why I'm here. I'd like to give you a little bit more about information about the inheritance and crypto assets and how not to lose them. So that is tonight's agenda. I'm going to give you an overview about the purpose of inheritance law, and I'm going to talk thereafter about the succession principles and the succession challenges. And then we're going to go ahead with the planning on how not to lose your crypto assets, and also in case of incapability of judgment, how not to leave your crypto assets fallow. As I said, at the end, we're going to have some time for your questions. So what is the purpose of inheritance law according to Swiss law? Inheritance law regulates the succession and the transfer of assets upon death. It is very important to know that there are self-determination rules. So you have the possibility as a testator to draw up a last will, which is unilateral, or an inheritance contract that exists between multiple parties. For example, between you and your spouse, or you and your descendants, your children. If you do not draw up a last will, or if you do not conclude an inheritance contract, there are subsidiary rules that apply. So the law provides for statutory provisions in Article 457 until 640 in the Swiss Civil Code. And what you have to be aware of, unlike in other common law countries, we have forced heirship rules. I'm going to come back to that later. So what is the last will of a testator? An individual may dispose of his or her assets upon death by drawing up a last will. A last will must, in Switzerland, must be either handwritten, dated and signed, or it must be certified by a notary public in the presence of two witnesses. If you choose the latter, then the certification, you have a charge to pay to the notary. But apart from that, those forms, both forms are equal. So there is no advantage or disadvantage. They have the same value, except that if you choose the handwritten form, that you have to write it, from the beginning until the end by hand. It may take a little bit more time. If there is no last will, as I said, the statutory provisions apply. So what are the succession principles and what does the law provide for? If you are married, you always have to first think about the matrimonial property, because the division of the matrimonial property takes place before the inheritance division takes place. This is quite important because if you have crypto assets and if you want to bequeath them, for example, to a certain heir, for example, to your child, then you have to make sure that the crypto assets effectively are in your estate. That means if you do not have a matrimonial contract under Swiss law or foreign law, then you fall within the statutory regime of acquired property. I'd like to explain that a little bit further, not in every detail because it's too wide and it's too ample, but I'd like to give you some information about the acquired property. Under the acquired property, everything that you brought into your marriage is your own property, and the same applies to any inheritance that you receive during the marriage. So that is your own property. Simply speaking, the acquired property is your wage. So at the end, if one of the spouses passes away, then there is the matrimonial goods are divided. So every spouse takes back his own property, and the acquired property is simply said divided by 2. So you have to be aware of that before your estate is determined, the surviving spouse takes half of the acquired property. So you can set up a very well written last will, but if your crypto assets are not falling within your estate, then the last will serves for nothing. So be sure that you're clear about the matrimonial property situation. Once the inheritance division takes place, you have to know that we have the principle of the universal succession that is provided for in Article 560 of the Swiss Civil Code. That means that upon the death of the testator, the heirs inherit the whole estate and enter into the legal position of the testator. So they take the exactly same position as the testator had, with all the liabilities and assets, and also all the contract. That means, unlike in common law countries, they take over the estate and the assets per se by the law. So there is no probate that is going to be opened, which is like a kind of a intermediate action in other countries. It is the heirs that take over the property and the ownership. They also take over the rights and the intellectual property rights, the claims, the receivables, and the liabilities, as well as the crypto assets. So how will the estate be divided between the parties or the heirs? If you're not drawing up a last will, then the estate passes to the legal heirs as per the statutory order. That means if you're married, your spouse or registered partner will get half of the estate and the descendants will get the other half. If there are no descendants, then the estate is divided between the spouse and the parents. If there are no parents, the siblings will step into the parents' function. The surviving spouse, the registered partner, and the descendants, they have an enforceable claim to a compulsory share of the estate. So they have a forced heirship. The spouse or the registered partner, they get half of the statutory entitlement, and the descendants, they must get 3/4 of the statutory entitlement. So in an example speaking, if you're married and you're having kids, then your spouse has to get 1/4 or 2/8 of the estate, and the descendants altogether, they get 3/8 of the estate. So the free quota, that means the quota that you can give to any third individual or to a charity, for example, will be 3/8. Important to know is also that there is a revision ongoing at the moment. You may have heard about it in the newspaper or read in the newspaper about it. It is the case that the parents will no longer have a forced heirship, and the descendants' forced heirship will be reduced to 1/2. That means if the revision, and it is coming into effect most likely beginning of 2022, you have a bigger free quota. For example, if I speak again is that example that you are married and you are having children, then you have a free quota of 1/2. So you do that calculation. It depends what legal heirs do you have in order to decide what is your free quota, and your free quota is free to give to anyone. Another thing is that all the heirs, so whoever is the legal heir or the appointed heir, they form a community. That means all the assets belong to each heir. So that means the heirs can act or must act jointly. They have the asset jointly. They have to decide unanimously at all times. So they have to be in agreement with all your assets. So, for example, if one heir wants to liquidate the crypto assets and the other heirs, they do not agree, then crypto asset cannot be liquidated. It can be liquidated then if one of the heirs claims for a division of the inheritance. But otherwise, it's not possible. Then further, the testator may give directions regarding the estate division. So you can say, okay, I would like to have my eaters allocated to one heir only. Or you can also appoint, as I said, 30 individuals as heirs for a quota, for the free quota, for less than the free quota, joint together 2 individuals, or you appoint them as legatees. So you give them an item, or you say, okay, I give you all my Bitcoins. You always have to keep in mind the forced heirship rules, but otherwise you're free to appoint any third person individual as an heir or as a legatee. For you, important to know is the difference between an heir and a legatee. So as I said, an heir is taking over the same position as a testator. However, a legatee is not taking over the debt and not the same position at all. They only have an enforceable claim to a certain item or a certain amount of money. Then the testator may appoint an executor in the last will with exclusive power and authority to dispose of the estate assets. That is something the executor has by law. So he is free, even though the heirs are actually the owners of the estate, the executor is free to dispose of the assets. So he has the power to dispose, for example, liquidate the crypto assets. Together with that, he has the following duties. So he must administrate the estate, he must settle all the testator's debts, and he must distribute the legacies and do the division of the estate in accordance with the testator's instructions or as provided by law. So those are the main principles I'd like to mention before I go on with the crypto assets. So in this slide, you see our MME classification of the blockchain crypto property. And I think for the purpose of this virtual event, I will only gonna talk about the native utility tokens, or in the FEMA equivalent, the payment token. So I'd like to talk about the cryptocurrencies such as Bitcoin and Ethers, and I'm not going to talk about the counterparty tokens or ownership tokens. So how are crypto assets classified under civil law? Native payment and utility tokens, so for example, Bitcoins and Ether, they are factual intangible assets. And according to the current prevailing doctrine, a payment token is not recognized as a thing, because a thing needs, under Swiss civil law, it must be impersonal, it must be delimited, physical, and controllable. And the doctrine says, because the crypto assets, they have no physicality. They do not qualify as thing. The problem is we do not have that dogmatic explanation for the things, but we have facts, because the factual intangible assets, they may be included in the bankruptcy state, they may be seized, and they are also subject to taxes. So we have to challenge that we have factual, or we have the fact that crypto assets are owned, they are transferred, they are dealt with, but we do not have a legal basis for crypto assets in civil law and neither in the states. So a legal basis is missing. That's why we need to give that fact a legal basis. And in our view, a thing must be understood in a modern, contemporary, functional, factual method. That means it's not the physicality, it's more the fact that you are actually owning your crypto assets and are able to handle with those crypto assets or transfer them or to do anything with them. They must be regarded as a thing or as an item, so the property law standards can be applied in analogy to crypto assets. Once we have established that, we have to look at the inheritance of the crypto assets. So how does that work? I said, okay, they fall into the state, but what is there a difference between crypto assets held in a custodial wallet or crypto assets held in a non-custodial wallet? And yes, there is a difference. Because if you have crypto assets in a custodial wallet, you have a contractual relationship with SEBA, for example, or Signum or Bitcoin Swiss. You are having a custodian who is in charge, not in charge, but is like the custodian of your crypto assets. So you have an automatic transfer of the contractual relationship. As I mentioned earlier, all contractual relationship pass from the testator to the heirs. So the same applies now with the custodial wallet and the contract of the custodial wallet that will be bequeathed or passed on to the heirs. It's like a bank contract. You have a counterparty that you can count on, that you get information, you can obtain information from SEBA about the crypto assets, etc. So it's like a bank account. Crypto assets held in a non-custodial wallet, however, there is no contractual relationship, and I'm sure you're aware of that. Now they fall together with the wallet into the estate, because you have the principle of accessoriness, so they are in your estate. But the issue is, or the challenge is, what happens to the wallet PIN, the wallet address, or the seed phrase, because that is not passed on automatically. If you have a bank contract or a contract with a custodian, the heirs, they have the possibility, because they have a legal claim for information, to obtain the information from the custodian. But in a non-custodial wallet surrounding or a situation, they do not have a counterparty, so they can't ask anyone. So we have to make sure that in the planning, we think about that. We make sure that all that information, that access information, is passed on to the heirs or made accessible for the heirs. What is not critical to are items or objects, so like a laptop or a hardware wallet. Those items and objects, they fall within the estate, so you can either give them to a certain heir, or you can also appoint a legatee for that item. Now, what are the issues together with that, what I just mentioned with the non-custodial wallets? We have a lot of issues that people come and ask because the heirs are not familiar with crypto assets. We have a lot of heirs that are inheriting crypto assets, but they have not the slightest idea about how to administer or to handle those crypto assets. They have no helpline for non-custodial wallets, so they do not know who they can ask and who will give them more information about the crypto assets. Then we have another issue of the reversible transactions, because if the heirs, are not familiar with that and may type in their wallet address false, then, or falsely wrong, then the transaction cannot be reversed anymore. And from an inheritance perspective, it's quite good to know also that if you draw up a last will, that last will has to be submitted to the court or to the competent authority, and the competent authority will then open that last will. That means the authority will give the information of the last will to the heirs or to the legatees. That means that if you put in there any confidential information, it will be known by a lot of people. So it's not advisable to, for example, write a seed phrase into a last will. And as I said, if the testator held crypto assets in a non-custodial wallet, but the seed phrase, the pick or the book is not available, then the heirs are not able to access those crypto assets, and they, as I said in the beginning, they also die, and the crypto assets and the access are falling apart. So how are we going to do that now with the planning? Is there a solution? Yes, there is a solution. We have a lot of options to do and handle that within your estate planning. First, you are your own bank, but you are also your own planner. Think ahead, prepare your planning early, and because you are able to do it yourself, you can self-determine about your estate, and you also have the responsibility to do the division of your estate and look after your heirs. If you're having your crypto assets in a custodial wallet, then you can obtain an overview of the contractual death provisions from your custodian, and you can adjust them if needed. As far as the crypto assets are concerned that are held in a non-custodial wallet, we recommend that you draw up a crypto access plan consisting of a crypto assets inventory, wallet and access data, PIN, passphrase, 2FA, location of seed phrase, online exchanges, etc., and most probably in hard copy and in a sealed hard copy and not in a digital form. If you prefer to do it in a digital form, make sure that you also use an encrypted digital version, but then you have to ensure that the heirs get to know, your encryption program as well as the master password. So this is an additional hurdle. You have even more information to pass on, and you may give it a thought. Prepare your heirs and legatees if they are not familiar with crypto assets. Make them familiar with crypto assets, and determine a person of trust to be appointed as executor or helper. I'm going to talk about that in a moment. And draw up a last will and refer to crypto assets in the form of a simple reference. As I said, it's going to be public, so just say that you are possessing crypto assets, and also say or state in your last will where the location is of your crypto access plan. Now I have tried to compile some options. There are options with an appointed executor, and there are options with a helper. I'm going to talk about in a minute. I also took, for simplicity reasons and for this virtual event, a hardware wallet, and not any online wallet, so a cold or warm wallet. I did not make any difference. I just said, okay, we have a hardware wallet, and I tried to show you some options that you could consider for your estate planning. So the hardware wallet is at home. That is clear, in a safe place, because you use it during your lifetime, and it's most probably going to stay there. Then you have to decide where do you put your crypto access plan and your seed phrase. You should keep the two documents in two documents, and don't put it in one document, because if the executor is having the seed phrase, it's easier for him to access, the crypto assets. So keep it apart for security reasons. So you decide maybe to give the crypto access or deposit the crypto access plan with your executor, but put the seed phrase in a safe. And again, maybe you can also choose the other way around. You put your seed phrase into the safe and give your No, your crypto access plan, you deposit that in the safe, but the seed phrase you deposit with the executor. That's option 3. You can also keep 2 documents in the safe, or both documents with the executor, is subject to a lot of trust that you put into the executor. The last will can be either deposited with the executor or the community. There you have to obtain the information whether it is possible to deposit your last will with the community. Not all communities in Switzerland, they provide that service. With such an option, with those options, you make sure that the executor has the legal access to the estate assets and the safe. Because once that last will is given or is submitted to the competent authority in order to be opened, the executor will thereafter receive a certification that will legitimate him to access any estate assets. So he can then go to the bank and has access to the bank safe. He can also liquidate the crypto assets and distribute the assets or the money thereafter to the heirs. You can also give instructions to the executor. It can be a person of trust that is instructed maybe to liquidate the crypto assets once you have passed away. This is also the main advantage of an executor compared now to the options with an appointed helper. A helper has no mandate by the legal provisions. So it is like a third person. It's a person of trust, but it's not a person like the executor who has access to the estate. So again, here 3 options that you may consider. You use the helper as one person, and you need the self-storage or the safe, or again the helper for the second possibility to deposit something. So you can either deposit your crypto access plan with the helper and the seed phrase then with the self-storage place, or vice versa, at the safe and the seed phrase at the helper, option 3, or you choose to deposit the crypto access plan with the helper and the seed phrase at the bank, for example, in a safe. As far as the last will is concerned, the same applies, but you do not have the possibility to deposit your last will with the executor, but you may have the option with the community, or you can also put it into the safe. Again, it is very important to know that the helper has no authority to dispose of the assets. It's only a person of trust that can help the heirs to access the crypto assets. The thing or the issues that can arise is if one of the asset of the help or one of the heir has more information and more knowledge about the crypto assets. So he may access the crypto assets, transfer it to his own wallet, and they are gone. So you can give some instructions for the helper. You can tell him, okay, I would like my Bitcoins to go to, for example, my son. Then the helper should be instructed only to give information to the son. But because the heirs, they have a legal claim to get all the information, this may not be suitable. And it depends on it has to be regarded and reviewed on a case-by-case basis. So it's not a general option that you can take, or the best option. I can only give you the options to consider, and it depends then on the special circumstances you would like to consider and what option suits best for your needs and for your estate. 2 more things with that regard to the estate planning. Think about the unpaid taxes on crypto assets. So they are subject to taxes. If you do not pay taxes, then the heirs, they have a possibility of a one-time non-punishable voluntary disclosure, and they can disclose the undeclared assets, crypto assets, with the privilege that they only have to pay taxes 3 years prior to the testator's death, and not with a self-declaration that is the usual case. If the testator self-declares or itself or himself, herself declares the crypto assets, then it goes back for 10 years. The heirs, they have the privilege that it only goes back 3 years prior to the testator's death. And as a general input, do a regular review. Your crypto access plan must be adapted and amended due to changes in the crypto assets, in the access, etc. So you have to review it regularly, and the same applies also to your last will. So a 5 years review cycle is recommendable. So those are the options for estate planning. What we should not forget, however, is if something happens to you during your lifetime. So in the event of incapacity, of judgment resulting from illness or an accident, the law provides for a mandatory appointment of a representative by the Adult Protection Authority. You may have heard about that. So the Adult Protection Authority, they will appoint any third person, and it can be someone out and not being a close relative or not being someone of your close family. And that representative will handle the personal and the financial affairs and is responsible for legal representation. So also in such a case or such an event, you have the possibility again of your self-determination. You can appoint a trusted individual having crypto assets knowledge in an advanced care directive. It's the so-called Vorsorgeauftrag in German. So I call it here ACD. The ACD must either be handwritten, dated and signed, or certified by a notary public in the presence of 2 witnesses. So again, with charge, and again, the same form as the last will. With such a drawing up of an advanced care directive, you have the limited or the involvement of the Adult Protection Authority. They will no longer appoint any third person to be a representative, but they will only validate the ACD. So the ACD must submit it like a last will to the competent court or authority. It must be submitted to the Adult Protection Authority that is competent, and the Adult Protection Authority will validate the ACD and then will issue a certification for the representative. And with that certification, the representative then have access to all the information and access to all the assets the incapable person is possessing. With regard to an advanced care directive, we also have some recommendations. So you should carefully select your representative. You make sure that the representative has crypto assets affinity and is a person of trust. Give him clear directions regarding the administration of the crypto assets. So you may also refer to your crypto access plan in your advanced care directive. And you should also regulate whether the representative is entitled to a compensation. And compensation is not mandatory, but if you want to give him a compensation, you also have to limit or say what is his compensation, to give a range of compensation. You have to safely and accessibly store the ACD, and there it is important not in a bank safe, because if you are incapable and you're being represented by the representative does not have access to a bank safe. So it's better to keep in a safe place, for example, at home, or to deposit the advanced care directive as the last will, for example, with a notary or with the representative itself. You have the possibility to register the fact that you draw up advanced care directive with the InfoStar. That is a platform of all Swiss civil registry offices. It's subject to charge. And again, also with regard to the advanced care directive, we recommend a 5-year review cycle because the circumstances can always change. And this is more or less my input from my side, and I'm happy to answer any questions you may have now.
Thank you very much, Alexandra. I actually do have a question. First of all, thanks for. I think it's very helpful, not just for me probably, but everyone in the call who owns some coins. And I was just wondering, do you actually give, or do you have many professional clients, sort of, to say who want that already, or do you see like it is growing?
Yes, yeah, we have more and more. Yeah, I think that people realize that they should set up an estate planning. I mean, it's always a question. It depends a little bit on the age too. But we have a lot more and more clients asking for that.
Great, thanks a lot. I want to give the chance also to others to ask some questions. Doesn't look like it. Looks like everything is clear.
Okay, I mean, if you have more questions or questions come up, then you can contact me at any time.
Yes, absolutely. There is someone.
Yeah, excuse me. I was looking for the unmute button, and I needed time to find it. Thank you very much for the presentation. I was just wondering. Okay, there are specificities to the crypto assets, like you mentioned, the seed phrase. But I mean, shouldn't we do the same kind of plan for any non-physical assets?
For any non-physical, you mean, assets?
Yes.
Yeah, I mean, it always depends a little bit whether the assets are accessible or not. So once they need a password, then yes, it's fine. And if they, if there is no counterparty that the heirs can obtain the information from, then yes, it's advisable. And it also depends a little bit on your location and your tax return. A lot of information is in your tax return. But if you are, for example, in Singapore, you don't have a tax return. So I think you should think about anything you have, and where the heirs have no possibility to get the information, then you should plan that or make it accessible, that the information passes on somehow.
Yeah, right. Thank you.
Awesome. Someone else have any question? Otherwise, I would thank you very much. Everyone who has a question that comes up later, we just see the contact detail now of Alexandra. Feel free to contact her, also myself from SEBA, and we're happy to give you an answer. And from my side, thank you very much for joining, Alexandra. I hope you had fun, and maybe soon again.
Yeah, very good.
Okay. Thank you very much.
Okay, thank you very much, everyone.